What if the green card you have carried for years is no longer enough to guarantee your entry back into the United States? This is a question that is now circulating with urgency across immigration forums, social media groups, and legal networks, as multiple reports emerge of lawful permanent residents being stopped, questioned, and in some cases, turned away at American airports. The reason this story is spreading so quickly is because for decades, the green card has been viewed as one of the most secure immigration documents a person can hold. It represents lawful permanent resident status, the ability to live and work in the United States indefinitely, and a pathway to eventual citizenship. But what is happening right now at ports of entry is raising serious questions about how that status is being treated in practice. Reports suggest that Customs and Border Protection officers are applying heightened scrutiny to returning green card holders, particularly those who have spent extended periods of time outside the United States. Sources familiar with the situation indicate that travelers are being pulled into secondary inspection at higher rates than in previous years, and the nature of the questioning has become more aggressive. Officers are reportedly asking detailed questions about the purpose of travel, the length of stay abroad, employment status in the United States, family ties, and whether the traveler has maintained a primary residence on American soil. In some cases, green card holders are being asked to sign Form I-407, which is a formal abandonment of lawful permanent resident status. This is where the situation becomes especially alarming. Signing this form is voluntary, and no traveler is legally required to do so. However, reports indicate that some officers are presenting the form in a way that makes travelers feel they have no choice. Immigration attorneys have raised concerns that individuals who do not fully understand their rights may be pressured into giving up their status on the spot. This is not a theoretical concern. Advocacy organizations have documented cases in which green card holders who had lived in the United States for decades were questioned for hours and ultimately told they could not enter unless they relinquished their status. To understand the legal context, it is important to know what can put a green card holder at risk when returning from abroad. Under current immigration law, absences of more than 180 days can trigger questions about whether the individual intended to abandon their residence. Absences of more than 1 year without a re-entry permit can be considered a formal break in status. And even shorter absences can become an issue if CBP determines that the traveler's primary life is no longer based in the United States. Factors that officers consider include where the person works, where their immediate family resides, whether they file taxes in the United States, whether they maintain a home or apartment, and whether they have active bank accounts and financial ties. What appears to be changing now is not the law itself, but the intensity with which it is being enforced. Sources indicate that internal guidance within DHS has encouraged officers to take a more rigorous approach when evaluating returning residents. This aligns with broader administration priorities around immigration enforcement and the stated goal of ensuring that immigration benefits are not being misused. Critics argue that this approach unfairly targets long-term residents who may have legitimate reasons for extended travel, such as caring for elderly parents abroad, managing inherited property, or dealing with medical issues that required treatment in their home country. For those who may be affected, the situation requires immediate attention. Immigration attorneys recommend that green card holders who have been outside the United States for extended periods gather documentation before attempting to re-enter. This includes evidence of ongoing ties to the United States, such as lease agreements, mortgage statements, utility bills, employment letters, and tax returns. It also includes evidence explaining the purpose and necessity of the trip abroad. If a re-entry permit was obtained before departure, travelers should have that document readily available. If not, travelers should be prepared to explain in detail why the absence occurred and why they intend to resume permanent residence. It is also critical for travelers to understand their rights at the port of entry. Green card holders have more rights than visitors or visa holders, but those rights are not absolute. If questioned, travelers should remain calm, answer honestly, and avoid signing any documents without fully understanding what they mean. If an officer presents Form I-407, travelers have the right to decline to sign. Doing so may result in being placed into removal proceedings, but it also preserves the opportunity to present a case before an immigration judge. Travelers who feel they were treated improperly or coerced into signing documents should contact an immigration attorney immediately. There may be options to challenge the action, especially if evidence shows that the traveler did not intend to abandon their status. At the institutional level, DHS has not issued a formal public statement acknowledging a shift in policy toward green card holders at airports. CBP continues to state that each traveler is evaluated on a case-by-case basis, and that officers are simply applying existing law. However, the pattern of reports from attorneys, travelers, and advocacy groups suggests a noticeable change in enforcement posture. This is particularly concerning for seniors who may travel abroad for extended periods to be with family or to manage health issues. It is also concerning for individuals who work in industries that require international travel or who have binational families. For now, the situation remains uncertain. Green card holders should be aware that their status, while powerful, does not exempt them from scrutiny at the border. Those planning international travel should prepare thoroughly and consult with an immigration attorney if they have any concerns about their travel history or ties to the United States. This is an evolving situation, and further developments may emerge as more cases are reported and as legal challenges move through the system.